first event sponsored by the Diversity Committee here at Brandeis School of Law and the Office of Student Affairs and Diversity. We're going to have a discussion where all viewpoints are welcomed. To give you your moderator today, it is my pleasure. She is a 2L. She's an amazing student. And we thank Ms. Lauren Neal for being our moderator today. On behalf of the Diversity Committee, co-chair Professor Cedric Powell and myself and all the Diversity Committee members, we welcome all of you. Thank you for coming and being a part of this open discussion of all viewpoints. On behalf of the Office of the Dean, we have two representatives, Ms. Jackie Gutterman. The Dean Smith, was unable to be with us today, but of course he brings his regards, and we're happy to have the Executive Assistant, Ms. Jackie Gutterman, with us, and of course the Associate Dean for Academic Affairs, Dr. Joanne Sweeney. Dean Sweeney, thank you guys both for joining us. And the other faculty who are here, there are several of you, thank you so much for coming out. Now I'm turning it over to our moderator. And yes, I'm Dean Coel, Office of Student Affairs and Diversity. Thrilled to be with you. Ms. Lauren Neal, take it over. I'm out. There you go. Ms. Neal, thank
you. Each year, the Diversity Committee will host a big event to help remind us of why we're at law school and why we need to be critical thinkers. Welcome, my name is Lauren Neal, and I'm a 2L here at Brandeis. I will serve as your moderator today as we explore reproductive freedom and state power, privacy, autonomy, and the politics of choice. While today's discussion will be generally focused on reproductive freedom, we will focus on specific issues concerning the case Whole Woman's Health versus Austin Reeve Jackson, the Texas anti-abortion law, which criminalizes most abortions after 6 weeks and allows for citizens to enforce state anti-abortion laws. We will also touch on local events and policy implications and what reproductive justice is. This past Friday, the Supreme Court declined to block the Texas anti-abortion law on an emergency basis, scheduling oral arguments for November 1st on whether Texas's abortion law violates a constitutional right. Justice Sotomayor wrote a partial dissent stating, "There is in no dispute that under this court's precedents, women have a constitutional right to seek abortion care prior to viability. But Senate Bill 8 was created to frustrate the right by raising seemingly novel procedural issues and has precisely the intended effect." She concludes with, "Every day that Senate bill remains in effect is a day in which such tactics are rewarded, and every day the scheme succeeds increases the likelihood that it will be adapted to attack other federal constitutional rights." To help us reflect on this important issue, we are fortunate to have three amazing panelists. Our first panelist is, her pronouns are she, her. She is a 2015 graduate of Harvard Law School, where she was president of the Legal Aid Bureau. She also received her bachelor's summa cum laude and a master of public health from Yale. She also has her Master of Science in Public Management and Governance from the London School of Economics. As a Skadden Fellow, she worked as an attorney at the Louisville Legal Aid Society and the Kentucky Equal Justice Center, where she designed and implemented a comprehensive program to provide legal services to rural victims of domestic violence. Most recently, she has worked as an associate at the Louisville firm of Kaplan Johnson Abate Byrd, and she has also held several prestigious judicial clerkships. This native Kentuckian grew up in Eastern Kentucky, and her book, recently published, is entitled Hill Women: Finding Family and a Way Forward in the Appalachian Mountains. She was elected to the Louisville Metro City Council District 8 seat in June 2020, and for the past 3 years has been vice chair of the Kentucky Democratic Party. She is one of our favorite Brandeis scholars, Professor Cassie Chambers Armstrong. Please give a round of applause. Our second panelist, pronouns are she, they. They are a active professional who serves at Kentucky State as the Kentucky State Director for the Planned Parenthood Alliance Advocates based in Louisville. As State Director, They manage organizing, advocacy, and electoral efforts to promote, protect, and advance access to sexual health, education, and reproductive rights in Kentucky. Prior to joining the team at Planned Parenthood of Indiana and Kentucky in 2015, she worked for the ACLU. She holds a master's in international relations and diplomacy, where she specializes in global health and reproductive rights. Here's a strong advocate for reproductive rights, Ms. Tammara Wieder. Our third and final panelist, the pronouns are she, they, received a bachelor's degree in Pan-African Studies and her Juris Doctor from the University of Louisville. She is currently pursuing a master's in Public Policy and Administration from Northwestern University. Before joining the Loring Project, she was a legal fellow for the ACLU of Kentucky and If, When, How Reproductive Justice Fellow for the Women's Law Project and New Voices for Reproductive Justice. She served as both the Partnership Fellow and student teacher with the university's Pipeline program at Central High School. As a product of the Central High Partnership, she was able to teach in both street law and Marshall Brennan programs. She was awarded the Samuel L. Greenbaum Public Service Award. Here's an attorney who has dedicated her legal career to high-impact litigation for equal access to reproductive health care and reproductive justice policies on the state and federal levels. Please welcome Mashayla Hayes, Esquire. Now we will move on to allow each panelist about 10 minutes to discuss their work and engagement surrounding reproductive justice freedom and discuss their thoughts and ideas around our central theme of the panel today. I'll ask those questions after you all give us your backgrounds.
Let's go this way. Yep. Great. Oh, here's the microphone. Oh, this is very fancy. Hi, everyone. I am Cassie Chambers Armstrong, and it is an honor to be here with you all today. I'm going to talk a little bit specifically about some of the policy work that's been happening at the local government level, and then hopefully in the conversation we'll get into ideas around how this intersects at a state and at a national level. So I'm going to talk specifically, and I believe some other panelists might talk about it from their perspective as well, about the safety zone ordinance that was passed by Louisville Metro government several months back. So for those of you who haven't heard of the safety zone ordinance, the safety zone ordinance created a 10-foot area of space in front of the entrance of any healthcare facility, right? A healthcare facility of any type could apply to create this zone. And in that zone, no one is allowed to obstruct, detain, hinder, impede, or block anyone who's trying to get into the entrance of the healthcare facility. Sounds pretty non-controversial, right? We can all agree healthcare facilities, people should be able to freely enter and exit. We could think of all kinds of different contexts where accessing a healthcare facility without being obstructed, detained, hindered, impeded, or blocked is important. But this became a very controversial ordinance because one of the places that we had the greatest need for this in our city was outside of the EMW Women's Clinic downtown, which used to be the only abortion care provider in Kentucky and is now one of two. And so regularly in front of the EMW clinic, you would have protesters, some of whom were there exercising their First Amendment right peacefully, others of whom were engaging in action as opposed to speech. So in from January 2020 through that year, there were 39 911 calls for service to EMW, plus 7 calls for service to addresses on the other side. There were 101 311 non-emergency reports. There were 21 arrests. And additionally, we know through our legal observer data, because the clinic had put into place a legal observer program, that we had 122 assaults or batteries, 96 patients who were followed or harassed. There were 249 incidents of trespassing and 174 incidents of people obstructing the loading zone or the entrance either with bodies or signs. So this was a place where one of the tactics people were using was to try to actually obstruct people from entering this particular healthcare facility, and sort of using the delayed time, using those tactics to engage in what they referred to as sidewalk counseling, what many of us might refer to as harassment, to people who were trying to enter the EMW clinic. So I want to talk really briefly about how this ordinance was different than other ordinances that we see. So on Metro Council, we pass a lot of policies. We meet every other week. You're welcome to come down. I will give you a tour. Come see local government in action. We do a lot more things than most people realize we do, and it's a lot more important than a lot of people realize that it is. But this ordinance was different for a couple of reasons. One, it had been tried once before. So last year, someone had introduced a safety zone that failed by one vote. Am I right? One vote? So it failed by one vote previously. And so we sort of knew that there was a roadmap of this ordinance and sort of what a pathway to success would look like, what a pathway to failure would look like, and what a lot of the issues that people would be concerned about would be. It was also different, in part, based on what we knew. We knew that questions of law were going to be more important to the debate than they usually are for ordinances. Most of the time when we are debating ordinances, we talk about the policy reasons behind them. We sort of talk about conflicting things we care about, fairness, justice, equality. All of those things are what guide our conversation. This one was unique because the major opposition argument was, this is unconstitutional. And the reason they claimed it was unconstitutional is because it is setting aside a part of a public sidewalk and saying that the public generally cannot be there. And that raises First Amendment rights issues. And there's a long body of Supreme Court jurisprudence that talks about that. Typically, when we talk about the First Amendment sort of forum and the gathering of the public and places where people are supposed to come together and have ideas, public sidewalks were a big part of that. And so there are very strict and stringent requirements around when you can say that a public sidewalk isn't for whatever purpose the public would like to use it for. And so we knew that that's how it was going to be framed by people who were opposed to this ordinance. And so I want to just briefly, since we are at a law school, talk very quickly about what the law is on these questions, because there's a pending court case right now that I hope that you all will follow along with to see how this local issue plays out. It's currently in federal district court. So in order, we are not the first city to pass a safety zone ordinance that would allow a healthcare facility to set aside this buffer zone, this safe space in front of the entrance to their clinic. There have been a lot of other cities that have done it, and they have all faced legal challenges, and some of those have gone all the way up to the United States Supreme Court. So because we have these First Amendment issues, and when reviewing it, a court's going to look to see if the zone, the ordinance, is narrowly tailored to serve a significant government interest. It's going to sound a little bit like intermediate scrutiny to you all that have had constitutional law. You're right, it's sort of in that intermediate scrutiny area. And so it's pretty clear that allowing folks access to reproductive health care without being blocked, assaulted, impeded, without experiencing these kinds of things. Courts have pretty consistently said that is a legitimate government interest. The government has a legitimate interest in doing that. What was interesting, as a policymaker, I had to put on my lawyer hat because we actually had to build a record around that when we were having our hearings. We actually had to sort of do like a lawyer would do and put evidence into our legislative record around what our interest was. So we had doctors who worked at EMW come testify about how patients that had to walk through the crowd of protesters, many of whom would follow them for several blocks, and they'd have to make a 2-minute walk. They would have elevated heart rate, high blood pressure, how that could lead to medical complications, how there were public safety issues, the use of public resources around having lots of police calls, lots of police responses, and had to build a record on that. But courts have been pretty clear that that's a legitimate government interest. Really what a lot of these cases turn on is the specific ordinance narrowly tailored? And narrow tailoring means, in this context, is it as small as it could possibly be to achieve your goal? So there was a Supreme Court case several years back that said a 35-foot area with sort of both a space but also a prohibition on approaching people in that space, that was not narrowly tailored. That was too big. But recently there have been court cases that have said that 15 feet is narrowly tailored, that a 15-foot stretch sort of directly from an entrance to a curb is fine. And so we wrote ours. Ours is one of the narrowest in the country at 10 feet. And so we were trying to get in that narrowly tailored prong. The other thing that was different about this ordinance than some other ordinances was the support that we had from our state and national partners, one of which is sitting right here beside me. So we knew when we passed this ordinance that it would likely be challenged in court, and we knew that it would have precedential value for any other city that's looking at this. And so we had a lot of support working with folks engaged in reproductive justice work all throughout the country in getting this right and in mobilizing the support and in dealing with shepherding this through successfully. And so that's different than what we do with a lot of our just regular plain old change in zoning ordinances. And so it was very interesting to be able to work with our great state and national level partners. A few takeaways from this experience, and then I hope that we can get more into how what's happening in Louisville intersects with national and state level conversations, why Louisville was perhaps able to do something small, a small positive policy forward to protect access to abortion care, at least in a very small way, in an otherwise sea of that's sweeping the other way. I think there are some interesting things to get into there. But my very quick takeaways, one, I realized the importance that this was framed as a public safety issue, which as someone who cares about access to abortion care because people should have access to abortion care, the fact that we had to talk about it only as a public safety measure, only as people are being assaulted, people are being battered, people on both sides, a lot of times you would have companions that would understandably be like, you are harassing the person that I am here as a companion to, and they might get physical. There would be physicality both directions. And so talking about it that way was not really talking about the issue of access to care. But that was sort of the only way to build a coalition at this moment in our city to get the votes we needed to get it through. Additionally, the importance of counting and recounting your votes. It was very close the first time it went through. It was very close this time around, and I'd be happy to answer any questions that you all might have in the Q&A about what was different this time around. I think the major lesson was really around making sure every single day that the votes were there, making deals where you had to, talking about it in the way that people could find palatable in their district. And I think that was one of the things that helped us build a coalition that got this across the finish line. And finally, the importance of what our state and national partners and state and national government end up doing on these issues, because it was the hardest thing I have done as a legislator to get the safety zone ordinance through. It was very difficult. It took hours of my time and hours of many other people's time doing this work. It took a big coalition of partners. It could all be preempted by the General Assembly passing a law saying no city shall create any buffer zones outside of healthcare facilities. It could all go away like that. We expect, some other folks might talk about this, but that there will be efforts to do that. So now the next wave of action and advocacy on this is focused on how do we frame this now to try to slow down any state attempts to undo what we did here locally. And so one thing that can be frustrating as a local legislator is realizing how much you are bound by what other policymakers decide to do. And so with that, I will stop my remarks and turn it on over to some of these other folks to pick up on those ideas.
Thank you so much for including me as the non-lawyer. I'm really excited to be in this room. I had very little legal training in my international relations program. I studied international law, and it is in no way what you all are doing today. So thank you for being the future leaders of tomorrow. But I have been with Planned Parenthood now for 7 years, and it's a really different environment even in Kentucky from when I began. So we had the last Democratic House in the South back in 2015, and that was really a fail-safe. It stopped anti-abortion bills from passing in the legislature, and that went away with the election of 2016. So we started 2017 with an onslaught of bills. So just from 2017 to this past legislative session, 2021, we've had 11 anti-abortion bills pass, and sweeping restrictions hit across our Commonwealth on abortion access. And it really reflects a troubling trend that we see across the country in hostile states to abortion access, because it coincides also with our maternal mortality and infant mortality numbers too. We see a direct correlation with how our infant and maternal mortality numbers coincide when you don't have access, and it's not good. We have some of the worst data in the country. Even when we're looking at data around cervical cancer deaths, one of the most treatable cancers in the states, we have the 7th highest mortality rate to cervical cancer. So we have real big gaps to care. And when you're stigmatizing healthcare and you're stigmatizing the providers that give the care, especially around abortion services, you're really creating an uphill battle for the basic reproductive rights care in this state. But going back specifically, one of the questions was, is Roe still viable, I believe? And for the time being, yes. I think that it's going to change as we go into the 2022 cycle, especially with the Texas case being heard in a few weeks. And everything that's come out of SB 8. We know in Kentucky we have very excited opposition to move bills like this forward. Soon after the Texas SB 8 passed, Representative Joe Fisher and Senator Whitney Westerfield disclosed publicly that they were considering filing their own version of the Texas bill here in Kentucky. That's along with a laundry list of other legislative priorities, one of which was heard last week. We had an omnibus anti-abortion hearing last Wednesday in Frankfort, that brought together about 7 different bills. Now, we haven't actually seen the bill, but we had an informational hearing last week that's pretty much thrown in the kitchen sink on anything relating to access to abortion, and including care for other individuals. And I think when we look at abortion services, when I'm fighting in Frankfurt, it's not just abortion services. There are intersectional pieces here that coincide with healthcare, and specifically when we're talking about LGBTQ population, there's this one bill that they filed the last 3 years called the Conscience Bill, the Conscience Clause, that would deny anybody, whether it was a receptionist, a janitor, a nurse, a doctor, from denying services for any reason. So, you could be denied being checked in for your appointment. You could be denied a cleaning in your hospital room because they don't agree with whatever, if it was an abortion, if it was a miscarriage, if it is, LGBTQ status. This is also wrapped into the omnibus anti-abortion bill, at least as it was presented last week. And so we see all these intersecting bills that fall into the work that we're doing. They're coming and attacking on so many fronts. And it's only become more emboldened. When we first started seeing the bills pass, it came at informed consent, and there were exemptions. There were exemptions for rape, for incest, for fetal anomaly. There were wide exemptions for life of the mother. And I'd say in 2018, we started to see those stop. We started to see rape and incest exemptions. We stopped seeing fetal anomaly exemptions. And the exemptions for life of the mother started to become very narrowly tailored. On the 20-week ban specifically, we saw that if you are in a medical emergency and you go into an emergency room, maybe you're having a miscarriage, 2 providers that are not connected with each other have to agree that you need a therapeutic abortion, is the term in most hospitals, but they can't be connected, and then you have to be transported to a facility with a high-level neonatal intensive care unit. When we're talking about Kentucky, that's leaving Louisville and Lexington alone. Like, that's it. So if you're in a rural community, if you're far away from Louisville and Lexington, when you have narrowly tailored provisions like this, you're putting people in jeopardy. And you're putting hospitals in really precarious positions when they don't know how to really read these laws, because they are very confusing. And that's one of the questions we get all the time. How do we read this? We get calls from other providers across the state asking for guidance. And so as we move forward now into what I'm going to call probably like the new frontier with Texas, it's one of those, the sue thy neighbor, the vigilante piece of the Texas bill is terrifying to me, and how this is going to impact care, how this is going to impact our already struggling reproductive health care situation in Kentucky. Over 60% of our counties don't have a practicing OBGYN. What's going to happen to that if they're terrified about providing essential reproductive health care services in an emergency because somebody's going to turn them in? There's a lot to unpack here, and it just continues to move to this extreme level of it just continues to move to the extreme. And even in such a short period of time of, I'd say like 5 years, we've had 11 anti-abortion bills move, and the exemptions have disappeared. We also, if you are a registered Kentucky voter, you are going to be voting on abortion on the 2022 ballot. We have a constitutional amendment that will be on the ballot next year that will ban abortion in the Kentucky Constitution. I mean, so it's become so extreme, and they're coming at us on all fronts. I'm going to hand it on over to the RJ lawyer. I feel like I'm kind of a Debbie Downer.
Thanks. It's always good to come back, and I always like to tell folks that I kind of stumbled upon the RJ movement. For folks who are 3Ls and even 2Ls, you'll start looking for jobs, and for me, I was lucky enough that right at the peak of when all of this abortion stuff started happening in Kentucky, the ACLU had an internship, and they hadn't had an internship in a really long time. And I got to go downtown at the Federal Building and hear the arguments for the first abortion ban that Kentucky had passed in years, as Tammara said, and it was the transfer transport agreement. So it required abortion clinics here to have transfer transport agreements with local hospitals, so that basically in the case of an emergency, they already had a partnership with 911 to come and pick someone up, which is what 911 already does. But I'll be nice today. That was one of the first lawsuits, and I was kind of thrown into it, and I fell in love with the movement and the work from that very short summer that I spent with them, and was able to move on to actual RJ fellowship with If, When, How, and it provides fellowships for 3Ls who graduate. Generally, they pick about 7 folks. When I joined, I got sent to Pittsburgh, so I went and lived in Pittsburgh for a year, and there were some other folks that went to Seattle and DC. And now the fellowship specifically focused for the Southwest, Southeastern region. I'm on the board, and so we're trying to figure out exactly where fellows should go, where is the work needed the most. But within that, I think specifically because I had about 3 years of fellowship experience, my involvement and my experience and my views on RJ have shifted a lot. So specifically with the ACLU, so we had the transfer transport agreement case. Then there was the D&E, so it banned a procedure that usually is performed in the second trimester. Then there was the ultrasound, where the physicians had to show the patient the ultrasound and let them hear the heartbeat. Then there was the 6-week, abortion ban that we all seen recently, and the reason ban. So it's just been like a continuation of things that have been happening, and specifically now, the Kentucky AG it went to the Supreme Court. They had a hearing, and I was like, I did research on that. Yes. But it went up to the Supreme Court, and I think it's really interesting when you start to see how just within, just thinking very basic civil procedure, how the case moved, how it was won on the ACLU's behalf both times, and yet still during political change, political shifts, elections are so important. We see that because because the previous AG, he had decided that they weren't going to be involved in the case, but because a new AG stepped into office, he wanted to be involved in the case, and so he continued to pursue all the way up until the Supreme Court and got in. So when we're talking about finding avenues of like wins, like those wins were great, and then those wins also kind of fall down into political environment and political interference a lot. And specifically, when I was in Pittsburgh, I had a lot of different experiences with abortion. The Women's Law Project and New Voices had very similar views, but also took very different routes. So the Women's Law Project is kind of sort of set up like an ACLU just so folks can follow. And I spent a lot of my time doing judicial bypasses, so helping young people have access to abortion. We had a few folks from Kentucky actually drive all the way up to Pennsylvania. That's a 6-hour drive just to get access. And it was really interesting hearing their stories, their struggles, their barriers. I mean, I know, well, I'm 28. I still think I'm kind of young, but if you could just think back to when you were in high school, one, I definitely didn't have sex ed. I knew the very basics, but still, like, sex ed is very non-existent in a state like Kentucky, and is very non-existent in a state like Pennsylvania as well. And so when folks, you know, things happen, and to have a young person trying to navigate the legal system on their own, trying to find a lawyer to represent them in this hearing, trying to find funding. It really changed my perspective on the movement a lot. And we had 2 cases at the Women's Law Project. One was actually about anti-protesters, actually. There was they also had a barrier, or I'm forgetting the name already.
Buffer zone.
Yes, buffer zone. They had a buffer zone as well, but there were folks who were like crossing the buffer zone and all that thing. So I was actually a legal observer, and that was a very interesting experience as well. And just to kind of see the layout, especially, I think it was in like November, December. It was really cold in Pittsburgh at the time, but the amount of people there, the tactics that folks use to kind of lure people in, like fake clinics. There's I don't want to say fake clinic, but that's what I guess we call it at work. But there is a clinic right beside the EMW clinic that kind of on their website will say like, oh yes, come in, we'll give you all the options. And then when you go in, they do not give you all the options. In Pittsburgh, there was a van who actually went around to say that they gave like free mammograms. They were not giving free mammograms. They would specifically park in front of low-income neighborhoods and tried to persuade them, if they like saw someone who looked to be pregnant, and tried to persuade them to keep their pregnancy if they saw them kind of moving toward the abortion clinic. They very strategically parked to where they like, this is the intersection, this is where we're going to be. So we had a case about that. There was also an anti-protester who was trying to get all the names of anybody who was on the board, who worked there previously, all the nurses, all the drivers, like anybody you can think of, all the funders, anybody who had donated to a clinic, wanted the names, addresses, phone numbers, all the personal information for anybody who had helped any of the clinics in Pennsylvania. And I think that was the case that really opened my eyes to just how vast this movement is growing and just how serious the danger is. I think for a lot of people it's really easy to say like, you know, I support the movement, and then you can kind of separate yourself. But for the people who are in the movement every day and providing the care, the danger is real. And so we did win that case, and so we didn't have to turn over any personal information. But it's something that happens a lot. They try to find all kind of ways to get your information. And I'm trying to think. After I left the Women's Law Project, I was there for the very end, but they are currently trying to see what it looks like to reopen Medicare to actually provide funding for abortion access for low-income families, which is something that federally hasn't been able. Let's see. Look, I'm trying to think. I don't even know when that passed. It's been a long time. The Hyde Amendment, yeah. So it's been a long time as far as when we're talking about people who have government insurance and then not being able to actually cover health care, abortion care with your health insurance. You know, I go to the doctor all the time and I don't think twice about it. But the moment that you find yourself in that predicament is the moment that all of a sudden health insurance isn't really health insurance. So it's a lot of different interesting views that I've had, and now I'm at the lawyering project. So now I do mostly policy work, particularly because I felt that litigation is always needed. It's going to be around and it's great, but sometimes it's just a little reactive, you know, like you can't do anything until something happens. And it happened a lot when I was at the ACLU. We heard about all of these bills coming. Like I did research for the omnibus bill, and it's just like the kitchen sink. It really reminded me of like a tort exam, and just like a professor just throws everything in there. It's just like, yeah, figure it out. Like it's everything you can think of imaginable. And it was almost like 100 pages. And I was like, this is ridiculous. But I had to do research on it. I had to analyze it. I had to break it down. I had to figure out like what's going to happen. What are the nuances? Yeah.
That was last year.
And I don't want to know what this year's is. I don't want to know. But it happened a lot. And I'm just like, we know this is happening. Why can't we do anything? And the staff attorney there, Heather Gatton-Eric, would always be like, we got to wait. It has to pass first. We have to wait. We got to wait for it to take effect, and then we can file. And all we can do now is like prepare so we can get the lawsuit ready. And hope that, you know, we catch it in enough time to where we can inform the clinic and they can inform their patients. Because then in the midst of all of these things happening and everything in the mood, there are people who are trying to get access, you know, and they're looking on the news, and the news is portraying different versions of what's happening and saying, you know, abortion is no more. And they're just like, well, I have a you know, appointment tomorrow. So then it's all that misinformation that you're trying to detangle and let people know. And so now I do mostly policy work, and Senate Bill 8 has definitely increased my workload. And there's just a lot of people. So specifically, I think a lot of times, again, the repro movement, especially the litigation and lawsuits, they focus on clinics. But at the Lawyering Project, we focus on everybody else who's affected. And when I mean everybody else, I mean folks like James Due Process in Texas, where all they do is judicial bypass. They're not a clinic. They don't provide care. They help people get care. We're talking about abortion funders, nationally, state-based, anybody who's just kind of in the movement, but kind of behind the screens. You know, they're just helping people get car rides, give gas cards. They're helping people make appointments, or, you know, provide services for aftercare, like whatever it is that they need. And so all of those people tend to go unnoticed, or have been, until Senate Bill 8 passed. So now Senate Bill 8 caused so much of an uproar that people who are just funders, like all they do is help give people, you know, financial assistance to get the care that they need. And they themselves were wondering, well, how am I implicated? Does this affect me? Am I going to be sued because I helped give somebody a ride? Am I going to be sued because I gave somebody money? And so that's been a lot of my work. And particularly, we've been focusing on the states around Texas, because that's where folks have been going. They've been having to drive. I think the average time here in Kentucky is like 3 to 4 hours. Yeah, Texas is way more than that. We're talking 6, 7, 8 to get to another state, depending on where you are. So thinking about what it means for folks just in this day and era. And it's really interesting. So the Women's Law Project, we have 2 teams. There is a litigation team who is actually getting ready for oral arguments for the Supreme Court in November. And there's 2 cases. So there's the initial case that was brought, which the women... Whole Women's Health v. Jackson, that was the case that was brought in Texas, and then the U.S. Department, so the actual federal government got involved, and so the Supreme Court is going to be hearing both of those cases, and still hasn't ruled on the stay. So Senate Bill 8 is still in effect, and as long as it stays in effect, I'm going to continue to have folks reach out to me, looking for answers, looking for help, understanding Senate Bill 8 and all its implications, but also people who are currently looking to expand abortion access through telemedicine and telehealth. I think that's the new wave that we're kind of seeing shift here, trying to get people access, especially to the pill through telehealth. And so a lot of folks, even though I think the Texas ban just kind of revved it up, and so people are looking to do it a lot quicker than maybe initially was part of their strategy. So there's now this push now, so people are just like, I need analysis on like Maryland, Michigan, Georgia, Alabama. I was like, okay, you got to give me like a month. This goes like, give me some time, because I'm going through all these different states, but that's what's happening now. And I think generally I love this work, and it's very emotional at times, but I think just generally speaking, it just I often wonder how we got to this point. I wonder at what point it became a thing to just interfere with people's everyday lives. I wonder where we got to a point of just pure, I don't want to say pure, but just like kind of disrespect. Like if someone doesn't think the way you think, all of a sudden there's like no room for common ground. There's no room for allyship on other issues, and I think that's what's changed the movement the most. At one point, people had their views about a lot of different things, and at some point it became a thing of there's no privacy and people just kind of coming at you. And so since I joined the Lawyer in Project, I have now been subject to the same type of things I've talked about. I get emails all the time now. And it's the first time I've had to experience it. And so I've had to like have conversations with my family and my friends. I've had to change my Facebook, a lot of things. But I stay in the movement because there's still hope in the movement. And it looks like people like me graduating and having the desire and the passion to keep it moving forward. But there's certainly still a lot to do.
Thank you. You actually, yes, you can give a round of applause. You actually set it up just perfectly for my next question. We have about 20-ish, 15 minutes. So I'll ask this question and then we'll open up the questions for the audience. As we're preparing for November 1st, which will address the Texas anti-abortion law, and then as we prepare for December 1st, I believe that's when the Supreme Court scheduled oral arguments concerning the case in the Dobbs case, Dobbs versus Jackson, yes, the Mississippi court case that directly challenges Roe v. Wade. How are we going to prepare? What's that look like when we're talking about impact litigation? What's that look like when we're talking about policy? And what's that look like personally as well? And then we'll open up the audience to ask questions.
I'm going to quickly just answer on like the healthcare services side of it. So we are seeing patients from Texas and Kentucky right now because the border states are overwhelmed with patients trying to get abortion care in New Mexico and Colorado. They're coming here too. So like there is a massive strategy on trying to make sure that there is access in states, no matter what comes out of the legislation, but it impacts us and it impacts the people that we care for, even in Kentucky. And I just want to make that known. And I think this has been a long game strategy. And I wish I had said this earlier, but the strategy to where we found ourselves here, for the last 7 years, nobody in Frankfurt on the other side has cared about legal precedent because they knew that they had been setting up the courts, they'd been stacking the courts, that they were getting to a moment where the Supreme Court would get them to a place where they could dismantle Roe. So this was a long game strategy that they were able to successfully play out, especially as we're seeing without any injunctions going in Texas. But I did want to just talk about the person, like the people impact, the impact that's happening on people, because they are even coming to Kentucky to get care. And when we think about care in Kentucky, there's only 2 abortion providers in the state, in the entire state, and yet we have people from Texas coming here to access it.
No, go.
So I guess the only thing that I would add to that as someone who did impact litigation is just to talk a little bit about how people tend to prepare for these things. I'm not involved in this particular impact litigation, but, well, and you can certainly speak to the impact litigation as well. But there are a lot of organizations who will be doing a lot of moot courts. There are a lot of organizations that will be sort of working together to make sure that every contingency that could be addressed is addressed and that folks are ready to go. I think what will be interesting to see is the other panelists have spoken a little bit about the emboldenedness effect that has happened and the way that the discourse around this has become so charged and so heated. And I will say we saw this with the safety zone too, where when we have these moments can be really scary, quite frankly. because you have a lot of people. One of the things that we learned as we were preparing for the safety zone vote, and as we were looking at the protesters, was the number of protesters, anti-abortion protesters, who have ties to Operation Save America and some of the groups that were present at the January 6th storming of the Capitol. And we learned about FBI action and investigations into that. And we saw a little bit, as the safety zone has been implemented and as it's begun to be enforced, the way that that's become a moment for anti-abortion protesters to sort of test the limits, test sort of the mechanisms, test the law. And when there wasn't a very swift and very line in the sand response, people very quickly became emboldened, and the situation at the EMW clinic escalated very quickly. And so what I am concerned about and what I will be looking for is the way that these moments in our legal system, a lot of people don't understand the ins and outs of the Supreme Court. They do understand that this is a moment where a lot of anti-abortion protesters feel like they have an opportunity to win what they've been trying to win for a really long time. And so I think one thing to watch for is the way that that shapes the discourse and all of the other things that are happening in our society.
The only thing I'll add, which touches on my work, is just what it's going to look like. So if and it's about if it limits to 15 weeks, but also thinking more broadly, if for whatever reason, like Roe is gone, most, RJ and our reproductive rights organizations have looked at this. And so what it's going to look like is all red, like in the southern Midwest region. And then there's going to be, except for Illinois, like you can go up there, you can have care. And then there's like New York and Maryland and all those folks. And there's California, Seattle. And then there's just a couple of like hit miss folks, maybe or maybe not. Like there's a couple of folks that are in the womb, are up in the air, and we don't know what they'll do, but just looking at their policies, it shows that they will probably be one of the states to offer care. So then what does it look like for all the southern and Midwest states to be going to those states and trying to get there, and if there's any legal implications from it? And so that's a big part of my work right now, and it's trying to do cross-state work. It's just going to ramp up the more we get the closer we get to the argument, but then especially the in-between time. So between December and next summer, when we're, expect to have the decision, it's just going to be a lot of ramping up on the ground and within policy and legal teams as well, just trying to get ready for the different possibilities of what could happen.
I'll add to that too. One thing we haven't talked about is the local ordinances for sanctuary cities that we've seen pop up across the country, and this is something that Metro councils are doing to, I think, stop. We see them on border areas, on areas that somebody may be crossing to get an abortion. So like in northern Kentucky, we actually saw one that failed. But we're seeing them pop up where you could be turned in. It's similar to the Texas law, where it's like an aiding and abetting and you can't leave and get an abortion. And so we do anticipate seeing more of those, especially along if there becomes a sort of like a sanctuary city for people to go and get abortions along border states. So that you would have to cross through one of these sanctuary cities that could set up roadblocks for you getting into those areas. And it's a terrifying prospect. We haven't seen a whole lot of them pass. I think one did pass in Lebanon, Ohio, recently, I think last summer. Does that sound right? I don't know. I guess I get in the weeds on some of these because it is something that we're really tracking because it's at the Metro Council level, and it's actually really hard to follow compared to like statewide legislatures. Like it's easier to slide them in. But it is something that we're seeing pop up across the country. I know Manatee County, Florida has one, and I believe it is Lebanon, Ohio, if you want to look into that as well.
So we'll open up to audience questions. Anybody have, Frank?
So it's kind of a two-part. I know that some states like Kentucky have, and I believe Kentucky has a trigger. And what's kind of the point where it comes into effect? Because I've heard a lot of people on the radio and podcasts saying it's unlikely to fully overturn Roe v. Wade. It's likely they'll chip away at Roe v. Wade over time.
The trigger constitutional bans?
Trigger
Okay.
constitutional ban? Like what's kind of, how much could they erode it till that comes into effect? And how are people preparing during the interim period where you're waiting for decision to come out that could erode?
I was about to say, I only know about the constitutional
I
ban.
could talk about the trigger law. So in 2019, we had a trigger law passed in Kentucky. So this meant that if Roe is changed in whole or in part, that becomes the law of the land immediately. It has an emergency clause, so immediately upon the decision. So let's say that they do decide that 15 weeks is viability, or they go further, that would immediately become law in Kentucky. So it's different from the constitutional amendment. What was the other part of the question? What are we doing to prepare for it?
Yeah, kind of what's being done to prepare for it, because it would become in effect upon the Supreme Court enactment.
Yeah, and so one of the things too, when originally when the court dismissed Texas's SB 8 originally, there were a lot of questions, does that become part of a trigger law immediately? But because it was on like the shadow docket and it wasn't like a decision, that does not become part of a trigger law. So we did get asked that, but when it comes to, it will be like, let's say the end of June, we get a decision from the Supreme Court. However that is written, that will become law of Kentucky.
And how would that affect, say, two-part care, for example?
Sure.
One phase could theoretically happen before the decision being announced in the second.
Sure, so if it, depending on how it's written, like, because we don't know how it's going to be written, but let's say that they stop like 15 weeks, at 15 weeks. So we will no longer be able to provide abortions past 15 weeks, which is very normal. Most places go up to about 20 weeks. 24, 25 weeks is about considered viability in the country. So like in Kentucky, I believe EMW only goes to 20 weeks because of our state, because of our 20-week ban. So they only go up to that. So they would have to then shift forward. Planned Parenthood only goes to 13.6 weeks, so it wouldn't actually directly impact our care if it was only read at 15 weeks. But we, of course, are always considering, like, what if they go further? What if they take it further? What does this mean for our patients? And of course, how do we get them access to care? There is a long game strategy. I mean, we have lots of calls and conversations because 36 million people who can get pregnant are likely impacted by what's going to come out of the Supreme Court in June. So that is what's predicted from this. 36 million people are going to lose access to abortion care, and how are we going to be able to create a framework that is accessible? I mean, it's not going to be accessible. It's exactly what they want, but how do we create a system that at least can support some form of access in the states? And so, I mean, those conversations are going on and above my level too.
Any other questions?
So I'll kind of direct this at you, Professor Armstrong, but I know that this is explained as a right to privacy equal commitment issue, but I think that with this pendulum swing of cases, it's kind of moving towards practically us affording people rights to a Vida. And so do you think that then in turn has the potential to have an effect on other kinds of laws? So like maybe tort law with a wrongful death or trial plan or any other type of law, how do you think that this could potentially affect just outside of that point?
That's a good question.
Yeah, I think that's a really interesting connection to make. It was one that I made for the first time when I was teaching wrongful death last year. I was like, wait a second, as this area of law changes. So I think you're right, that as we start granting more rights to fetuses, that things like wrongful death claims, and if someone is injured while they are pregnant and the fetus is injured as a result, sort of how we think about those things, I think that will be a really interesting area of law to follow, and I'd be happy to chat with you more about the specifics, but I think you're right that it will, the sort of legal framework will begin to shift and change. Does anyone else want to add anything to that, Mashayla?
No, I don't
don't think so, but I do know that there was at least one. I think it was like a case that came up, and I can't remember where, but we kind of talked about it a little bit at the ACLU. There was a parent who was seeking custody of a fetus, and so we all kind of like tilted our heads to the side, like I don't understand how this is happening. But I think as soon as you said that, I was like, man, that's a good question. I wonder what's going to happen. Like, how do you kind of determine the life of a fetus? And I know specifically what came to mind for me is the damages, and like a lot of times damages are rewarded to like, well, they would have went on to do this and made this much money and did this, but how do you determine that for someone who isn't here yet? You know, like how do you do that? So I think it'll definitely be interesting to see what happens.
I'll say in Frankfurt, they do talk a lot about, they take into terms around other issues too. So most recently during the special session, it was around vaccine mandates, and several legislators talked about how both the born and the unborn had medical privacy. And so I don't know how that will be written in, and it may not even be around abortion that they write it in, but like that has a lot of implications around both, around abortion access. And we go ahead. No, go ahead.
No, I was just going to ask if anyone, I know I saw that there was a person who sued for child support on behalf of a fetus. Does anyone know how that case turned out? I believe it was filed after the Texas ban went into effect.
No, I did see the headline though. I haven't followed it.
Yeah, so it might be an interesting case to look into how it's going. The idea being this person was like, well, if I have to stay pregnant and I have to carry this pregnancy to term, I would like the child support to start now, thank you. So it'll be interesting to see how that plays out.
What are things that we can do to show support, or like what are ways that we can be more active?
Please volunteer for me. No, there are so many organizations too in Kentucky. So like definitely like Planned Parenthood needs support. We need, we're always taking interns during the legislative session, and hint to people that I've talked to, but also being really cognizant of what's moving. I think they move these bills so fast that they don't expect people to follow them, to read the bills, to call and hold them to account. So the legislative session starts January 3rd. So they're probably going to move 3 to 4 bills that first week. And I think they don't expect people to pay attention, especially coming right after the holidays, and they don't. Vote. Vote. If you're not registered to vote. We have abortion on the ballot. And vote. Make sure that you're voting in all of the places like Metro Council. Make sure you're voting for school board. Make sure that you are doing your research, because there is so much happening on the municipal and local levels that impact care and access to reproductive rights. There are abortion funders. There's the Kentucky Health Justice Network that makes sure that people have transportation, they have funding for abortion, that they have translators, that they have daycare, that they have support to get across all these barriers, which are a lot in Kentucky, to get access to abortion. Become an ad litem, do judicial bypass, which is in the omnibus bill. I will tell you, they are coming for judicial bypass, and so you can definitely talk to me offline. There's lots of work to do with us, and I can connect you if you have interest. And I think actually, Mashayla, aren't you on the board for KHJN? So she can talk to you about that too.
I think generally just getting in the movement is hard. So if you have interest in like a career in repro, please reach out, because it can be kind of hard to just kind of get in. Honestly, funding is a thing for a lot of people, and a lot of this work is nonprofit work.
We pay.
There you go. So, but if you have questions about that, happy to. But that's also a way, if you think this is what you want to do, I can talk to you about fellowship experiences, who to look for, who to look to. There are plenty of internships. Both the ACLU that I used to work for and the Lawyering Project, they both have summer internships for law students. We have a fellow now at the Lawyering Project. The ACLU also has a fellowship program, as you all know. So there's plenty of career things, but also I think just volunteering is a big thing. And what Tammara said was right. Like a lot of the General Assembly, like we know that it happens. Like looking back on my law school career, I knew what was happening, but I didn't follow it. And so there's like so many readings that have to be done. Then they usually open the floor for testimony. That's when you get them. That's when nobody shows up, and it's usually the same people. You know, it's Planned Parenthood, it's ACLU, and it might be like one other person that, you know, one of us finds to come and testify. But that's when, you know, the shift came. I don't know if the shift will still happen in Kentucky, because honestly, we're just Kentucky. But I think generally speaking, it's a way to kind of give other people the chance to see that it's not just them. I think a lot of people kind of sit back, have their views, and don't speak up. But at this point in time, that's what we need. Like, we need people to feel empowered to speak up and to talk about their views and to say the word abortion. Like, it's not stigma, it's not a dirty word. Like, we need people to do that, and the only way that that's going to happen is if other people see around them that, okay, you do support me. I think there's been a lot of silencing from people not speaking up, and from people following trends and just kind of knocking people down and knocking down the movement. So, like, be that person for someone, and the thing about that is that you don't know who they are. I have one of my favorite shirts is everyone loves someone who's had an abortion, and I say that because you never know who's sitting beside you and what they've been through, what their parents have been through, their grandparents, their cousin, their best friend. So really thinking about it more generally, of just like talking about it in the open, because that's where a lot of this is coming from, of just stigma of just not talking about it.
Yeah, and I did want to end, like, I know we're getting close on time, but I want to give some hope. So we did polling, 65% of Kentuckians support access to abortion. They're tired of it being regulated to the point of non-existence, because there are no exemptions. There are very few limitations for life of the mother, and like, they've pushed these bills so far to the extreme. So there is some hope here. And in 2020, we went from 1 abortion provider to 2. So even in hostile circumstances, we can increase our access. And we didn't have any anti-abortion bill. Granted, it was like the first year of COVID, but we didn't have any anti-abortion bills passed in 2020, which was, you know, it was nice. It was really nice. Like, and we have to, I mean, there were circumstances around it, but you have to take those wins and build off of them, and then have the safety zone, which was just this huge win, and to have this energy and excitement come from leaders like Councilwoman Armstrong. Like, it's incredible to see what can happen, and like, know that you're not alone, and that more of Kentucky is with us than against us on this issue than you would actually believe. And so stop taking us for granted.
All right, well, as we wrap up, are there any other closing? Oh, yeah, go ahead.
We have it.
Yeah, please go ahead.
So, obviously, being forced to carry the baby to term in any situation is awful, but if it's with the mother's risk of health in those specific situations, what legal remedies like, what options do they have? I guess it would be the family and the state of those mothers. Like, what options do they have afterwards? Or is it just sovereign immunity completely blocks everything?
It depends on the situation. Like, I know of a pregnancy of a friend who is 21 weeks that doesn't have a viable pregnancy. She's in cancer remission. And it's one of those situations where they've gotten some support, but it was really lucky that they did, because it depends on where you are. And like, some people may have to leave the state and go to like Chicago. They may have to go to New Mexico, even for a non-viable fetus, even for a life of the mother, depending on the situations. It's case-by-case basis, and the hospitals have these boards that they set up that will review and decide whether that they'll move forward with you. And so it's very like individual case basis, and that's part of the problem, that hospital systems are afraid to do these. Louisville's a little different, and I think the hospitals, a certain hospital has some flexibility here, but it's only one hospital.
So even though, for like, let's say worst case scenario, a mother is in a rural part of Kentucky, or let's say, I think you said it was an SB8 who requires the 2 doctors.
Oh, it was the 20-week ban. Yeah, so.
Yeah, so like, let's say, unfortunately, the mother let's say the mother does unfortunately not make it because she was denied that abortion, and therefore, what is available for her family afterward? Or is there any remedy?
the Kentucky, I'm telling you, these laws that are passed, they don't think about that. That's the nuance behind it. Like, there is nothing technically there to say like, oh, if for whatever reason this happens, this is what, that's not the intention of these bills. Like, maternal health in Kentucky has been going down for years, and we've recently, like, Representative Scott passed, had all these bills, and I helped draft them, and like we were doing all this momentum behind them, and it doesn't move because that's not what people care about right now. That's not what the legislature is showing that they care about. What they care about is saving the fetuses.
Yeah.
And after that, that's whatever happens.
And I think, that was something we brought up too. We said, what about the tragic circumstances where somebody's going to die? And they just,
No.
next. Like, they don't even want to address it. We brought up Ireland. Ireland specifically, like, reversed, based upon, really tragic circumstances where providers and hospitals didn't know what to do during, like, active miscarriages, and a lot of women went septic. And one legislator behind closed doors laughed at me and said, oh, well, that's not going to happen, and then shooed me out. I mean, they're not thinking through the end game here.
Yeah.
And I think that it speaks to how callous these bills are. And I think they're not expecting people to really look into the narrowly tailored definitions. They'll say, oh yeah, life of the mother is included. But then they're not expecting you to read how narrowly tailored it is. It's very narrowly tailored.
As we wrap up, are there any closing remarks from any of you? All right, well, let's do another round of applause. Thank you so much for taking the time to talk with us today, and thank you all for attending, and that's a wrap.
Thank you to the office.